I do for a workout today, Coach?
Well, for warm-ups, why don't you start with 10 100s? Hi, Roz.
Hi, Coach.
How are you?
Hi, Don.
Okay, then I'll get the team ready.
Okay, I'll be out with you in a second. Come on in. What can I do for you?
Well, I've been swimming since I was little, and I'm now on the girls' swim team at school, so I'm not getting any competition.
So what are you saying, Roz?
I'd like to be on the boys' swim team.
Wow, that's going to create problems.
What kind of problems?
Well, problems with league rules, allowing a girl to swim on the boys' team.
Well, how do you feel about me being on the boys' team?
I'd like to have you. You're a strong swimmer.
Well, what do you think we can do about it?
Well, maybe we can set up a match with you and Don and get the principal down to see it and get him on our side. Would you be willing to do something like that?
Yeah.
Okay, great.
Ready? Ho!
Hi, Mr. Nelson.
Hi, Coach. I understand you've got a race for me to see.
Yeah, we have a 100-yard individual medley.
What do they swim in the medley?
Well, it's 4 lengths, starting with the butterfly, the backstroke, breaststroke, and finally the freestyle.
Sounds like a good race.
Okay, I'll get it going. Okay, clear the pool. Everybody in the stands. Roz and Don on the line. Roz, Don, you're going to swim a 100-yard individual medley. Take your marks. Ho!
Congratulations, you two. That was a very impressive race.
Thank you.
Thank you very much.
So what do you think about Roz swimming on the boys' varsity team?
And she's obviously a strong enough swimmer to compete with the boys. But there's a state athletic federation bylaw that prohibits girls from taking part on boys' teams.
Does that mean that I can't swim on the boys' team?
It means just that.
Well, what can be done?
Nothing can be done unless they change the state bylaws. We could be suspended from all athletic competition if we violated the law. No, I'm sorry. We could use another good swimmer.
What happened at school today, Roz?
Well, I've been trying to get on the boys' swim team.
Right.
Coach Downey set up a match between me and Don, and we had our little race.
And how did it come out?
Oh, it came out all right, but Don won.
Did he? Well, Did you swim well?
Yeah, I swam pretty good. The principal was there, and he saw the race, and he said we swam pretty good, but he doesn't think he can do anything about it.
Oh, I suppose because of that rule about women not competing against men. Oh, Roz, I'm very sympathetic, as you might guess. Having coached you since you were 7 years old, I would really like to see you get ahead, and you're a good, strong swimmer. But I have a feeling that nothing's going to happen on this. We're really talking about sex discrimination, and it happens all over, in sports and in life generally. I believe that we're going to have to pursue it legally if anything's to happen. How would you feel about that?
Fine, yes.
And how about your parents?
They're with me.
They would back you up?
Yeah.
Well, I happen to know a lawyer, a woman, that I think would be very interested in this. Supposing I get in touch with her and have you talk to her.
That'll be
fine.
fine.
I do that?
Yeah.
Good, I will. Well, let's get into the pool and on with our workout.
Okay.
Roz, Virginia Moore, your swimming coach, called and told me you'd be coming to see me because your principal declared you ineligible to swim on your boys' swim team. I understand from her you're a very talented swimmer.
Thank you.
I've checked the bylaws of the State Interscholastic Federation. They indicate that first we should ask your local athletic league to make an exception in your case. If they won't do that, we can take it all the way to the state level. And if we can't get satisfaction that way, we'll have to bring a case in court. Are you prepared for that possibility?
Yes, it's fine with me. But my parents are concerned about the cost. How much will it cost us?
Roz, you won't have to worry about that. I think the issues in this case are important enough that we ought to pursue them even without my being paid. So that won't be a concern in the case.
Okay, thank you.
Mr. Nelson, I understand you're not only the principal of the school that Rosalind Wallace attends, you're also the president of the Pioneer League.
That's true. And the Pioneer League is an athletic conference of which this school is a member.
As her principal, you told Rosalind that even though she was qualified, she couldn't compete on the boys' swimming team because she was a girl. As president of the Pioneer League, can you authorize her to compete on the team?
No, I have no such authority. I can't change a state interscholastic federation bylaw which specifically states that girls are ineligible to compete on boys' teams.
But personally, do you agree with that rule?
No, as a matter of fact, I don't. I'd like to see it changed.
Well, what do you suggest we do in order to change it?
Well, I suggest that you go to the Southern Section office of the State Interscholastic Federation and request that the bylaw be amended.
The executive committee of the Southern Section has met, and her request was rejected.
But don't you think that developing the athletic abilities of girls as talented as Roz is important enough to warrant an exception?
There you have hit upon the thinking of the committee as we considered Rollins' case. We feel that the program is designed for the greatest value to the largest number of competitors. If we open the way for girls to compete on boys' team, conversely, we must also open the way for boys to compete on girls' teams. The disadvantages then would offset the advantages.
Do I understand you correctly, then, that you won't even make a recommendation that the state bylaw be changed?
You have the right to appeal the decision of the Southern Section to the State Athletic Board.
I speak on behalf of principals and superintendents who are elected to serve on the State Interscholastic Athletic Federation. We believe that swimming is a desirable sport for schoolgirls. Also, there should be teams so that girls can compete against girls from other high schools in league play. However, we feel that eligibility requirements should stand, namely, that girls are not eligible to compete on boys' teams.
Mr. March, my client has pursued her administrative remedies with the State Interscholastic Athletic Federation all the way to the state level. And at each stage along the way, her claim of sex discrimination has been denied. Finally, I filed a complaint in the district court here, and I understand you're going to be defending the state against it.
That's correct.
Even though my client is black, I haven't added a claim of racial discrimination, basically because I don't have the facts to support it right now.
Well, I don't think racial discrimination is a factor here. As you know, the school and the swimming team are both fully integrated.
That they've been acting in violation of my client's constitutional rights in denying her a place on the boys' team.
Can I convince you to drop your complaint?
Mr. Marsh, it looks like we're going to have to submit this one to the court. Can we at least get a prompt resolution of the issue? My client is eager to begin swimming as soon as the season starts, and that's soon.
Well, in fairness to your client, I think we should. I think the quickest way for me to proceed is to file a demurrer to your complaint.
I'll be prepared to respond. Hello, Roz. This is Carol Howard. I just wanted to tell you about the status of our case. The Interscholastic Federation has filed a demurrer, and there's going to be a hearing on it next Tuesday. No, it's not a trial. What the state is saying in this demurrer is that the Constitution affords us no relief at all, and therefore we ought to be thrown out of court even without a trial. You won't have to be there to testify, but I think you'd really find it interesting, and I'd like you to come. Good. I'll see you then.
Good morning, counsel. This is the case of Wallace versus State Interscholastic Athletic Federation. Are counsel ready?
Ready for the plaintiff, Your Honor.
Ready, Your Honor.
I think in this case I'd like to hear first from counsel representing Miss Wallace.
Thank you, Your Honor. My client has been discriminated against not because she is black, but solely because she is a woman. It is my contention that the Constitution, which protects her specially against discrimination because of her race, ought to be equally scrupulous in protecting her against discrimination because of her sex. It is true that Plaintiff's High School has both a girls' and a boys' swim team. But because of a bylaw of the State Interscholastic Federation, which says that girls may not participate on boys' teams, my client has been prevented from swimming on the team with the competition and the facilities that allow her to develop her talent to the fullest. That, Your Honor, is a denial of my client's rights under the 14th Amendment to the Equal Protection of the Laws. It is indistinguishable from racial discrimination for two reasons. First, sex, like race, is a trait my client did not choose and cannot change. Second, sex, like race, historically has served as the basis for systematic, purposeful, unequal treatment. Until the early years of the 20th century, women were prohibited by law from owning property, serving on juries, even voting. Just as the Supreme Court has not accepted racial stereotypes as justifications for discrimination against blacks, so this court should not permit convenient generalizations about differences in size and strength between the sexes to justify the adverse treatment my client has received. Thank you, Your Honor.
Thank you, Ms. Howard. Counsel?
The fundamental question this case raises is whether distinctions based on sex are constitutionally impermissible. Now, there are other questions, including the role of athletics in the educational process that the court may consider. But the basic issue, the issue this court is called upon to resolve, is whether the state can treat student athletes differently solely on the basis of their sex. Miss Wallace's counsel has suggested, indeed she's insisted, that a rigid requirement of total equality is just as proper for the sexes as it is for the races and just as workable. She bases this argument on the Equal Protection Clause of the 14th Amendment to the Constitution, which says that no state shall deny any person equal protection under the law. But the Equal Protection Clause does not require that all persons be treated alike in all circumstances. It merely requires that they be treated alike if they are the same. If they are not the same, if there are legitimate reasons for treating them differently, the state may treat them differently. The state does not dispute that sex, like race, is an immutable characteristic, a circumstance of birth, over which the individual has no control and which he or she is powerless to change. And we properly refuse to recognize any differences between the races that would justify different treatment under any circumstances. But we must recognize that there are differences in size and in strength between men and women. Now, these differences do not justify different treatment in most cases, but they do justify classifying separately girls and boys in our state's high school athletic programs. Separate treatment is permissible under the Equal Protection Clause if there are legitimate reasons for that treatment, and the state has legitimate reasons here. Differences in size and in strength are clearly related to the purposes of athletics in our high school programs. The Constitution of the United States does not prohibit separate treatment based on those differences. The court knows that it does not decide cases in a vacuum. The court's decision in this case is important, not only to Miss Wallace, but it will affect the life of every high school student in the state. Rosalind Wallace is an exceptional swimmer. She could win a place on any high school swimming team. But the principle she urges on this court today, that different treatment based on sex is impermissible, would prevent most girls from participating in high school athletics at all. Because the court must remember that if the Constitution requires that the boys' swimming team be integrated, the Constitution also requires that the girls' swimming team be integrated. And because high school boys as a group are larger and stronger than high school girls, the swimmers on both teams will be mostly boys. Now, what the state wants is a real opportunity for girls, for all girls, to compete in high school athletics, not just the exceptional girl. It's true that the girls' athletic program is not yet as fully developed or equal in every respect to the boys, but the school is making enormous progress. In years past, there were no girls' teams at all. The court should not interfere in that progress. The court should not hold as constitutional law that the right of every girl to participate in high school athletics is less deserving of protection than the right of a single girl to compete against boys. Aside from the narrow issue before this court, this case has broader implications. If this court decides today that the swimming team must be sexually integrated, will not the court have to decide tomorrow that the football team, the wrestling team be sexually integrated? Will not the court have to decide tomorrow that the locker room, that the shower be sexually integrated? In the light of our history and our culture, there are legitimate and compelling reasons for separating our boys and girls in these areas. We do not live, I hope we never live, in a unisexual society. There are differences between men and women. We all know that. It would be a mistake, a tragic mistake, for this court not to recognize those differences. I thank you, Your Honor.
Thank you, counsel. Ms. Howard, would you like to reply?
Thank you. Counsel for the Federation has just conceded that my client could compete on any high school team in the city. But the heart of this case is that Rosalind Wallace is not allowed to swim on the boys' team at her own high school. Repeated references to differences in size and strength between the sexes should not be permitted to obscure the fact that my client has demonstrated she can swim as well as any boy on her school's team. I gladly admit that boys and girls are not biologically the same, but their abilities overlap considerably in most fields of endeavor, and the state should be required to classify people on the basis of their own abilities, rather than on the basis of immutable traits such as sex, unless it has a compelling reason for doing otherwise. Opposing counsel has argued instead that this court should defer to the judgment of the state in matters of sex discrimination, so long as the state can offer a basis in reason or convenience for its actions. But when such deference was granted in the past to laws distinguishing between the races, the result was that courts upheld laws segregating blacks and whites in streetcars, in schoolhouses, and all in the name of judicial restraint. In spite of this, counsel for the Federation contends that unless this court defers to the state in this case, not only will girls' athletics suffer, but the Constitution will be construed to demand futilely that the states ignore real social and physical differences between the sexes. He has made a series of startled predictions about the consequences that will follow from a rule of sexual equality, in an effort to demonstrate that if my client is given the opportunity she so clearly deserves, more harm will come than good. I must disagree with this, Your Honor. The development of girl athletes less exceptional than Rosalind Wallace need not be compromised by the constitutional principle I recommend. Interscholastic teams could be provided for slower swimmers regardless of their sex, and boys and girls too good to compete on those teams could be required to compete against one another instead. But even if this alternative fails to protect girls' athletics, it is girls' athletics that should yield, not the principle of equality. We may feel that discrimination sometimes furthers admirable social goals that cannot otherwise be achieved. But unless those goals are more than admirable, unless they are socially indispensable, they should not be admitted as exceptions to the rule of equal treatment of the sexes. There can be limited exceptions for compelling circumstances under the Equal Protection Clause, and these exceptions would probably permit the state to maintain segregation in facilities such as restrooms and shower rooms. But unless the exception is limited to such extreme cases, Your Honor, women will continue to be denied needed constitutional protection against state rules based on sexual stereotypes. Discrimination will continue to create and exaggerate differences between the sexes. And these differences, in turn, will be offered as justifications for further discrimination. Women will continue to be excluded from well-paying jobs simply because some women aren't big enough or strong enough to perform them. And women will continue to be paid less for doing the same work as men. This process must be stopped. Our society can no longer afford to discourage excellence in its talented girls. Thank you, Your Honor.
Thank you, counsel. Each of you has given me a different set of predictions concerning what will happen to the school's athletic program if I decide Miss Wallace must be permitted to swim on the boys' team. However, the real issue for me to decide goes beyond the consequences that may or may not befall the school's athletic program. I must decide if the Equal Protection Clause of the United States Constitution requires that distinctions made on the basis of sex are to be prohibited in the same manner that the Constitution prohibits classifications or distinctions made on the basis of race. It is clear that the Constitution does not prohibit states from treating people differently in all cases. For example, a requirement that people must have certain educational credentials before being permitted to teach in our public schools would certainly be valid. Therefore, in this case, I must decide whether the reasons given for having separate men's and women's athletic programs are plausible. But beyond that, I must decide if plausible is enough. I must decide whether the reasons given must be strong and compelling ones. Obviously, these are important questions. I believe that I must take time in reaching my decision, and therefore I'm going to take this case under submission. When I have reached a decision, I will let you know. Thank you, counsel.